sir. Are we on? Good afternoon, ladies and gentlemen. Welcome to our podcast. This is Dr. Olu Asekun here. Welcome. This podcast is every Wednesday, by God's grace. Every Wednesday, 12 p.m. Dallas time. That is 12 p.m. Central Standard Time. Welcome again. Last week, we discussed asylum. We discussed asylum last week, and we are continuing with the topic today because we realize that it's a very, very broad and delicate topic that we cannot exhaust in one or two sessions. So that is why we are continuing today. So today, we are starting with one of the grounds for asylum, which is membership of particular social group. So we are starting with membership of particular social group. So under the membership of particular social group, we have female genital mutilation. Female genital mutilation. So that is the topic we'll be discussing today. So in the meantime, if you have questions, can you please display the number? Send in your numbers to 817-883-4495. 817-883-4495. So send in your questions. And again, remember to invite your friends, family, because this is a free program that we believe you should not be selfish. Let others also benefit from it. So invite family and friends. Send in your questions. We'll be discussing membership in a particular social group. That is the topic we'll be discussing today. We are still under asylum. So we will also be taking other questions regarding other aspects of asylum, but we are zeroing in on membership in a particular social group today. And more specifically, we'll be discussing female genital mutilation. That does not mean that if there are other questions on other areas relating to membership in a particular social group, we will not answer it, because female genital mutilation is not the only membership that is applicable in that category. You also have somebody who is a member of the LGBTQ community. They could also apply for asylum based on membership in a particular social group. But today we are focusing on female genital mutilation. Now, why is female genital mutilation so important? It is important because it is a very delicate topic. The way the immigration law works in the United States also makes it very, very technical for people to understand that somebody, for example, may apply for asylum based in a particular social group, maybe in Virginia or in New York, and be approved, while another person can apply for exactly the same thing in Dallas or in Houston or in New Orleans and be denied. So it is very important to understand all these things, especially when we are talking about affirmative asylum. There are two types of asylum. We have affirmative asylum and we have defensive asylum. In either case, the, the immigration office or the immigration court, as the case may be, that has jurisdiction over the area of residence of the applicant, it is the controlling precedent in that jurisdiction that the immigration office or the immigration court or the immigration judge will follow. And in the United States, there are different precedents. As I said earlier, the Board of Immigration Appeal is the appellate body regulating immigration filing, immigration proceedings, either through the immigration court or other immigration-related petitions or applications that one has the ability or the privilege to file an appeal. Now, there is only one Board of Immigration Appeal for the entire United States. But the same Board of Immigration Appeal uses precedent from different jurisdictions where the case originates. There are several federal court of appeals in the United States. For example, in Texas, it is the Fifth Circuit Court of Appeal that governs Texas. Now, if the Fifth Circuit came up with a decision that XYZ will be eligible for asylum, if another circuit, let's say somebody who is in New York, for example, I think New York is covered by Second Circuit, or maybe somebody from 10th Circuit. 10th Circuit are people from states like Colorado and all that. Now, let's say the 10th Circuit came up with a precedent decision that somebody is eligible for asylum based on female genital mutilation. Although the BIA is only one, but the BIA will have to rely on the 10th Circuit decision whenever they are dealing with cases that originate from Colorado. Whenever the BIA is dealing with cases that originate from Texas, they will have to rely on the decision from the Fifth Circuit Court of Appeal, which is a federal court of appeal that covers Texas among other states. So it is important to understand all these little technicalities. So you may see someone apply for asylum using female genital mutilation and that person getting approved based on the precedent in the person's jurisdiction. Another person using exactly the same thing may not be approved based on the precedent in that other person's local jurisdiction. Now, let me go further. While waiting for questions, let me go further. Female genital mutilation, one of the things that makes it a little complex and controversial is the fact that some courts believe that the act of mutilation itself is something that can only happen one time. And that once a woman has been circumcised once, that is the only time. And the person cannot suffer future persecution. But again, you have to look at the circuit, we have to look at the precedent from the area where an applicant is filing. Some circuits have ruled that, look, whether it's a one-time thing or not, you have to look at the severity of the persecution. One. Then two, you have to look at whether there is a possibility of that one-time mutilation to create additional problem. additional persecution for the applicant. Some courts have said that, whereas some courts have said that, look, female genital mutilation can only happen once. So once somebody has been circumcised once, there is no longer fear of persecution, and therefore such a person is no longer eligible for asylum. Again, the position of the government at any particular time depends on who is in power. It depends on the policy of the government in power at any particular time. Several times, USCIS policies have been changed to comply with the posture of the government of the day. So it depends on when an applicant submits an application, and it depends on the precedent from the jurisdiction where such a person is applying from. However, having said that, if the applicant has a child, a female child in particular, that the applicant intends to prevent from going through the same persecution, then the applicant can use that female child as evidence of future persecution. So it's very important. Let's see if questions have started coming in. Please send in your questions. Send in your questions. Send in your questions. I can't see the question. Can you help me with it? So how did you get to that page? I can't. Please continue to send in your questions. Thank you. Okay. Oh, this person says the volume is low. Okay. Okay, there's another question. What should I expect at the asylum interview based on FGM? Well, I would just advise you to listen to what we are discussing today. I cannot tell you precisely what to expect at an interview. Usually, asylum interview is conducted to verify that the applicant meets the eligibility requirement. And one of the eligibility requirements is one of the things that they do at interview is to review the asylum application with the applicant, ensure that all the information provided in the applications are accurate. They will ask you to verify your information, your marital record, your family history, parents' name, siblings' name, children's name, all those things. All the information that you completed in your Form I-589, you go through all of that. They verify it, and then, of course, they ask you about your story. You present your story. and then they verify your story, and the interview is over. Then they will tell you when to pick the. Is it not too? Is it not too high? The volume. Oh, they are still not hearing. Okay, well, I think we have a good volume right now because I can hear myself. Yeah, it's okay. So they verify all those information in the application. They ask you about your story. They verify it, and of course, they ask you about the security questions. Security question meaning your arrest history, criminal background, and all that. And once they get your story, they ask questions, they ask you to clarify it and everything, and the interview is over. Then they usually will get back to you within 2 to 3 weeks to let you know whether your case is approved. If approved, then you get the new I-94 and you get the approval letter. If not approved, if it's an affirmative asylum, USCIS does not have the authority to deny it, and because they cannot deny it, they have to send you to removal proceedings. They will give you a document called referral notice. So in that referral notice, they usually will include NTA, notice to appear, and ask you to go back to immigration court to go and represent your asylum. At that stage, your asylum becomes a defensive asylum application. You represent your case to the immigration court, and if the judge believes you, the judge has the authority to grant it. If they don't believe you, then the judge will order you removed back to your home country. So that is usually what happens in an asylum interview. Okay. I'm afraid for what can happen to my daughters. Can I file for asylum based on this? This is not very clear. I don't understand. Based on what? You can't just say you are afraid. Maybe you need to clarify the question. What do you mean by you are afraid of what will happen to your daughters? I have no idea what you are talking about. So you need to clarify it. Please, I don't want you to assume that I am in your mind. I can read your mind. I can know what you are thinking. This question is not clear at all, so I really don't understand. So the question is, are you a victim of FGM? Is FGM prevalent in your community? Is it prevalent in your culture? Is there evidence that there's no place to relocate to avoid being a victim? So if you meet all of these requirements, then you can, if your children are subject to persecution, or if there is fear of future persecution, or there has been evidence of past persecution, so that's the only way you can think about asylum. Let me say this. When we are talking about asylum, there are basic requirements that every applicant must meet in order to be eligible for asylum. And when we are talking about basic requirements, it is not enough to just say that you have a fear for yourself, or you have a fear for your children or something like that. That is not enough. For anybody applying for asylum, you have to show that you have been persecuted in the past. You have to show persecution in the past. And you have to show that during this persecution, the government of your country was unable or unwilling to protect you, or the government is the one that is persecuting you. So usually when we are talking about FGM, the government does not conduct FGM. In any country where FGM is prevalent, it usually does not come from the government. But if you can show that the government is unable to stop those who are persecuting you, those who are committing the circumcision, those who are carrying out the female genital mutilation, the government is unable to control them, or the government is unwilling to control them. Usually when something is cultural, the government does not interfere. In most African countries, for example, the government does not interfere in cultural things. Many times when you go to the police to go and report, especially if you meet a policeman or a policewoman who believes in the same culture, rather than protect you, they will actually blame you. Why don't you want to be part of the culture? Well, that's your culture. Why don't you just go ahead and do it? So they are not going to protect you. So you have to show that you have been persecuted in the past, or you have to show that you have a credible fear of future persecution. So it's not just enough to say that, you know what, I am afraid for my children. Oh, I'm afraid for my life. No, you have to show credible fear of future persecution. How do you show that? You have to show whatever has happened to you. There must have been, either you yourself have been a victim, you have been persecuted, you have been circumcised, you have been a victim of the female genital mutilation. That is evidence of past persecution. But if you are going to rely on future persecution, it must be credible. It's not just enough to say, I'm afraid for my children. No, you have to show credible evidence of future persecution. So that is the requirement in order to get the asylum. Next question. What kind of evidence do I need to present with my asylum application? Again, this is a question that I cannot answer, because the whole purpose of evidence is not to create evidence. For those who followed this program last week, there are certain things that we mentioned, especially I refer to page 9 of the asylum application, where it was written in bold, warning, applicants who are in the United States unlawfully will be subject to removal if their asylum claim or withholding of removal application is not granted by an asylum officer or an immigration judge. Applicants determined to have knowingly made a frivolous application for asylum will be permanently ineligible for any benefit under the Immigration and Nationality Act. You may not avoid a frivolous finding simply because someone advised you to provide false information in your asylum application. So I want you to understand this thing very clear. Asylum is very, very dangerous. If you are not eligible, please don't apply. Because if you apply and immigration conclude that your application is frivolous, it's a permanent bar. Even if you marry the American president after that, you cannot get legal document in this country. That is what the law says. I'm not the one that made the law, but that is what the law says. It's going to be a permanent bar. So it is very important that we understand what we are talking about here. So this is not about somebody who is just looking for something to file, and then you hear about asylum, then you go and submit an application for asylum. If the application is determined to be frivolous, it will create a permanent problem for you. Now, what does frivolous mean? Frivolous means that something that didn't happen, a story that was fabricated. Frivolous means fabrication, something that was fabricated, never happened, but it was fabricated. If immigration determines this, it will be a major problem. And guess what? This can be at any stage. It can even be after the asylum has been approved for you. It can be at any stage. It's something that they can come back even several years after approval. They can come back to revisit your case. So don't just submit application for asylum simply because you are hearing this discussion about asylum. The reason we are providing this information is to actually educate people so that you apply for the benefit you are eligible for. You apply for the benefit without making mistakes. That is the purpose. The purpose is not to create opportunity for people who are not eligible. So that caveat, please take note of it. Very, very important. Next question. So to go back to the question of evidence, what kind of evidence do I need to present with my asylum application? Well, the kind of evidence you present depends on the kind of story you are presenting. Remember, in every asylum case, you are going to have to present a story. You are going to tell them what you are afraid of. You are going to tell them the persecution that you have faced in the past. You are going to tell them that the persecution that you have fear of facing. You are going to tell them about everything that has happened to you. You are going to tell them why you cannot safely return home. So whatever evidence that will back up the story you are presenting, that is what you are going to have to show. So it is not a one cap fits all. It's not a situation where I'm going to tell you, oh, go and get this document, go and get that document. No, that's not the way it works. It must be document that support your story. It must be document that can give immigration the conviction that your story is credible. For example, if you claim that you have been prosecuted in the past, maybe you claim that you were forcefully detained and maybe taken to these people who conducted female genital mutilation on you and all of that. Yes, what happened after? Did you report to the police? If yes, you need police report. Did you go to the hospital after? If yes, you will need a medical report. So everything depends on what story you are presenting. So depending on your story is what will determine what document you will need to back up your story. Next question. Please keep the questions coming. I'm afraid that my children will be victims of FGM, but I haven't received any threat. Well, if you have not received any threat, you are not eligible for asylum because, like I said, there are two things before somebody can be eligible for asylum. Either you, as a parent, have been persecuted. You have been persecuted before, or your children have been persecuted before, or you have a credible fear of you or your children being persecuted. So if you have not received any threat, if nobody has threatened you, then you are not eligible for asylum in this category. And again, I must say this. There are countries or cultures where the government have actually taken active steps to prevent female genital mutilation. So if you are from such a culture, or you are from such a state, or you are from such a country, that is going to be an additional battle for you to overcome. It's going to be an additional battle because one of the major requirements is for you to show that the government is unwilling or unable to stop whoever is conducting this female genital mutilation thing. So where the government have actually taken steps, then it's going to be an additional hurdle for you to cross in order to get asylum. Let me give you an example. If, for example, you are from Nigeria, Nigeria is a country where the federal government has actually passed a law making it illegal for anybody to circumcise a child. So that is one of the battles you will have to face in order to prove that the government is unable or unwilling to protect you. Because if the government has actually made a law criminalizing this act, then it's going to be tough to turn around and say that the same government is not willing to protect you. It will be an additional hurdle for you to cross. And like I told you last week, remember that the Department of State is present in virtually every country. They know exactly what is going on in all these countries. And it is difficult for somebody to fabricate a story believing that the USCIS here will not know. Yes, USCIS may not know, but that is one of the reasons why they requested that application for asylum must be submitted in duplicate. And once you submit it in duplicate, one copies go to the Department of State, where this information or the story is actually verified. So you may think they will not know. They may know. Very important. If my daughters are minors, will they have to present during the asylum interview? Yes, every applicant must be present during the asylum interview. Yes, all of them will have to be present. It doesn't matter how small, how young, or how old they are. Everybody has to be present during asylum interview. Keep the questions coming. The next question is the approval percentage of asylum based on what is the approval percentage of asylum based on FGM? Well, I don't have that statistics. I don't have the statistics of what how many numbers immigration are approved based on FGM. But what I do know is the general asylum statistics, which is that 95% of asylum applications in the United States are denied. 95%. That is a whole lot of, I mean, if we have to convert that to academic exercise, that is A plus. that is excellent. That is A plus. 95% of asylum applications are denied. Basically for one reason, and in my opinion, that reason is because of ignorance on the part of applicants. I've said this before multiple times on this program. A lot of people apply for asylum, inviting the American government to come and violate the law of their country. A lot of people apply for asylum, inviting the American government to come and violate their country's sovereignty. Very important. Every single country has a sovereignty. Every single country has a form of government. Every single government has two responsibilities. The first responsibility is to protect its sovereignty, and that is why they have soldiers. The second responsibility of any government is to protect its citizens, and that is why they have the police. So when you are asking American government to come and protect you, they can only protect you if the harm is coming from the government who has the responsibility to protect you. But if you are asking them to come and protect you from something that the government of your country has the responsibility to protect you from, then you are inviting them to come and violate your country's sovereignty. And unfortunately, that is what majority of applications for asylum, that is what majority of applicants are doing. And that is why you have that many number of deniers. Very, very important. But if you understand the requirement and you understand what your responsibility is before applying for asylum, then I believe that the number will increase tremendously. But as it is, 95% of asylum applications are denied because people do not even understand what they are asking American government to do. They are asking the American government to come and violate their country's sovereignty, and America will not be a part of that. And that is why majority of applications for asylum is denied. So let's go back to the FGM questions. Will you recommend will you recommend filing asylum by myself, or do I really need an attorney to represent me? Well, that is entirely your choice. That is not something that I can tell you. One thing is important, as I've explained over and over and over, and I just did now. Understanding of what the requirement of the benefit you are seeking. Understanding the requirement is key, is a key requirement. So the fact that you use a lawyer will not change anything if you are not eligible for what you are applying for. The fact that you file it yourself will not change anything if you don't understand what you are applying for. So whether you to use a lawyer or not, that is entirely your choice. But I will tell you, if you want my sincere opinion, I will tell you, before you apply for asylum, have a consultation with an experienced immigration attorney. Ask questions. Make sure that you understand what the requirements are. Make sure that you meet this requirement before you apply. Because if you don't, as I've stated before now, and even now, as I've stated, asylum, especially affirmative asylum, it's a one-way benefit. Immigration officers, USCIS officers, they have only one-way authority. If they conduct an interview and they believe your story, they have the authority to approve your asylum application. If they conduct an interview and they don't believe your story, they do not have the authority to deny your application. And because they do not have the authority to deny your application, it is mandatory that they send you to removal proceedings. So they will issue a document called referral notice. They will send you to an immigration judge, and you know that way you are already on your way out. You will have the opportunity to represent your asylum claim to the immigration judge. But if the immigration judge does not believe you, there is only one thing he can do, that is to order you removed from the United States. So whether you use a lawyer or not, that is entirely your choice. Next question. I have my asylum application pending, but one of my children just passed in my country. Can I go back to my country to bury my son? Well, sorry about that. My condolences to whoever sent this question. But unfortunately, you have to make one choice. You cannot. And if you do, that will show that you can safely return to your country without fear of being persecuted. So it is only one thing. So that it is, if you go back to your home country, the possibility of the asylum application being denied is 99.9%. The possibility is 99.9%. The only reason I'm not going to use 100% is that if you actually have a legitimate claim, if you go back to your country to go and bury your son, the government may still arrest you again. New things may happen that could lead to you supplementing your pending application for asylum. But except such things happened, because remember, like I said, one of the grounds for asylum, you are saying that it is not safe for you to return to your home country. You are saying that your life will be in danger if you go back to your home country. So the question is, what changed now? So if you on your own now voluntarily return to your country, that will contradict whatever information you have provided in your application for asylum. So it will be a major obstacle for you to cross if you go back to your home country. But again, I left that 1% chance. That is why I said 99.9%. Next question. Please keep the questions coming. wanting to visit my children after 15 years. I left because deportation that was ordered for me when left by myself. Now, as a citizen of Canada, what should I do? My experience with US immigration not fun. Honestly, I don't see any question here, or maybe I don't understand it. It says, wanting to visit my children after 15 years. I left because deportation that was ordered for me when left by myself. Now, as a citizen of Canada, what should I do? My experience with US immigration not fun. Like I said, whoever sent this question, if you can clarify it, it will be helpful. When you say wanting to visit my children after 15 years, so are your children in the US, or I mean, you said I left because deportation that was ordered for me when I left by myself. So are you talking about visiting the US, or are you, I mean, I don't understand. Can you please clarify? I'm trying to I'm trying to have an understanding of what is going, or of what the question is saying. Or is it, well, don't let me assume. Please, can you just clarify it? So, wanting to visit your children after 15 years, where are your children? Are they in the US, or are you talking about going back to your home country after 15 years? Is that what you are referring to? So I'm trying to understand what the question is. Yeah, I know the person is trying to clarify, but again, it's still not good. The clarification is still not enough. You say just to visit. Where are you trying to visit? Are you coming to visit the US? Are your children here in the US? Are you talking about visiting your home country? Are your children in the home country? So that is what I'm trying to understand. And if you are coming to visit the US, I mean, to the best of my knowledge, Canadian citizens do not need a visa to come to the US. If that is the okay, children in the US, I want to visit. Yes, to the best of my knowledge, Canadian citizens do not require visa to come visit the US. If I believe that is the position, and I also know that American citizens do not need visa to visit Canada. So I really don't understand what the issue here. I don't see any issue here. If your children are here, if you are a Canadian citizen, you can come into the US to visit. I mean, Canadians are allowed to stay in the US for, I believe, up to 90 days. So I don't see any issue here. If the issue to you is because of your prior deportation, I don't think that will be an issue anymore, especially since you left on your own, for as long as the issue is not a criminal offense. If the issue is a criminal offense, even as a Canadian citizen, at the port of entry, you can still be prevented from entering the US if you are deported based on criminal issues. But if you are just deported, or you left the US on your own based on immigration violations, now that you have become a US citizen, I believe that now that you have become a Canadian citizen, I believe that Canadian citizens do not require a visa to come to the US. So the worst case scenario, at the port of entry, they can invite you for a secondary inspection and ask questions as to why you are here and all that. And you can tell them that, oh, I have my children here, I'm just here to visit. That is it. To my knowledge, Canadian citizens do not need visa to come to the US. Next question. Please keep the questions coming. What kind of benefit do we get while our application for asylum is pending? Well, it depends on how long your application has been pending. Um, Once your application for asylum has been pending for at least 180 days, which is 6 months, then from that moment, you are eligible to apply for employment authorization. And once you get your employment authorization, you are eligible to apply for social security number. You are eligible to work. You can do anything that people who are legal in this country can do. You can secure employment. You can even buy a home if you have the financial resources and you build your credit. You can do anything that anyone who is legal here can do in the US. Yeah, it gives you all of that benefit while your application for asylum is pending. The most important thing is the employment authorization, which you may be able to get once the application has been pending. Now, next question. I'm currently in Nigeria. Can I apply as for refugee status based on FGM? My husband's family want to get my daughter circumcised, and I can't let that happen. Well, to answer your question, yes, you can apply. I mean, if you want to apply for refugee status, you can apply through the American Embassy in Nigeria. You can apply. But the question is, are you eligible? That is the question. And like I told you, Nigerian government has actually made a law that makes it illegal, that makes it a crime for anybody in Nigeria to conduct FGM on anyone. So you will have this uphill battle of proving that the Nigerian government is not able to protect you. So even if you apply, the first question the embassy is going to ask you, okay, they threaten to circumcise your children. Did you report to the police? Because, like I said, that is a crime. So if somebody threatens to commit a crime, you have a responsibility to report it to the government. So you have to show all those things. So if you reported it to the government, what did the government do? What did they do? Did they arrest that person? Or is the person so powerful that even the government is not willing to interfere? I mean, those are the battle that you will need to win in order for you to get a refugee status based on FGM. So those are the things that yes, if anybody can apply for anything, it's like applying for visiting visa. Yes, anybody can apply, but it doesn't mean that they are going to give everybody who apply. So you can apply. The question is, do you meet the requirement? If yes, then they can give you refugee status. But remember, before they can give it to you, because this is like an indictment on the Nigerian government. It's like for them to give you a refugee status in Nigeria, it is like they are indicting the Nigerian government. It is either they are saying that the Nigerian government is complacent in this matter, or that the Nigerian government is irresponsible and not able to protect its own citizens. It's kind of it's going to be a negative finding on the Nigerian authorities before you can be granted a refugee status based on FGM. So, to the best of my knowledge, yes, you can apply, but are you eligible? That's a different question altogether. And as I've explained, in order to prove eligibility, you will have to show that there has been past persecution or a credible fear of future persecution. Those are the things that you need to prove. Please keep the questions coming. The next question. I no longer want to pursue my asylum application. I haven't been interviewed. Can I withdraw it? Well, I don't know who sent this question. I don't know if the person listened to us last week, because these are some of the areas we discussed extensively last week. And if you have your asylum application with you, I would tell you to go to page 9 of the asylum application. Even if you don't have the asylum application with you, for as long as you have access to Google, go on Google and type Form I-589. Form I-589. Go on Google and type it. It will bring out asylum application. So once the Google brings out that asylum application from I-589, go to page 9 of that application. And if you have your application handy with you, go to page 9 of the application. That page 9 is the signature page of the asylum application. That page 9 is the only page, is the only page in the entire asylum application that is written in bold under warning. I want you to read that place. Warning. Applicants who are in the United States unlawfully are subject to removal if their asylum application are not granted by an asylum officer or an immigration judge. Applicants determined to have made a frivolous application for asylum will be permanently ineligible for any benefit under the Immigration and Nationality Act. You may not avoid a frivolous finding simply because someone advised you to withdraw your asylum application. If you read further, you will see that that part that was written in bold, it went further to say that even if the application is later withdrawn, it's not going to change anything. So whether you withdraw your application or not, they will still assess your application and determine whether your story was frivolous or whether your story was credible. So if your story is credible but not approvable, yeah, that will not affect anything. You can still be, your asylum application can still be denied without a finding of frivolity. Like I said, frivolous means fabrication, something that never happened. It's a different ball game if they deny your application on the ground that you didn't prove your case. So if the immigration officer or the immigration judge conclude that you didn't prove your case, the only thing they can do is to deny your application. If you have other form of relief, you will still be able to get your legal status based on other form of relief. However, if they make that determination that your application is frivolous, whether or not you remove it, it means that you cannot get any benefit under the Immigration and Nationality Act. And that, of course, includes marriage. Marriage to a U.S. citizen, it will not make any difference. They will still deny it once a frivolous application has been made, once a frivolous determination has been made. So that is it. I think we have to take a short break right now. We need to take a short break, maybe like 2-3 minutes short break. Let's go. Welcome back. Okay. Keep the questions coming. Let me see what was my last question. Okay, I think my last question was I no longer want to pursue my asylum application. I haven't been interviewed yet. Can I withdraw it? Yes, as I think I've answered it. Yes, you can withdraw it, but of course, it does not affect the frivolous determination. So, for as long as there is no frivolous finding, you can withdraw it. But if there is frivolous finding, the withdrawal will not change anything at all. So, let's go to the next question. I had a medical examination performed in the US, but there were no FGM findings by the doctor. I know my truth. Will USCIS require proof of this? Well, what I would suggest is, why don't you, if you know your truth, if you know that you are circumcised, yes, you can get a second opinion. You can get a second opinion because I'm not sure if all doctors are trained in the act of FGM interrogation. Uh, I know that some doctors have forensic experience when it comes to forensic examination, making a determination as to whether someone was circumcised or not. Some doctors have those kind of experience, but some doctors don't. So you may want to get a second opinion. Of course, immigration is not going to insist that you present a evidence of a test, but of course, the burden is on you to prove your case. In any society, in any legal system all over the world, there is a legal maxim that says, "He who alleges must prove." So, since you are the one that is alleging to be a victim of FGM, it is your responsibility to prove that you are actually circumcised. So the doctor's report is actually going to help you to prove your case. So the government, USCIS, is not going to insist that you have to prove your case. They will just look at the facts presented. If it is sufficient, then they will approve it. If it is not sufficient, then they will tell you that you didn't meet your burden of proof. So if you get a doctor to confirm it, it is only helping you. It does not affect immigration in any way. And they are not going to insist that you be tested. No, that's not the way it works, because it is not their responsibility to prove the case. It is the responsibility of the applicant to prove the case. So the next question. I have asylum application pending, but my ex got my Venezuelan passport cancelled. But I already have my work permit and social security card, and I have a military dependent ID. Does it matter? No, it does not. It does not matter, because your passport has nothing to do with your eligibility. What is important is your eligibility, whether you are eligible for asylum or not. And I'm sure that when you file your asylum, you have presented your story. So whenever they invite you for interview, you will be getting interview relating to your story. It's not going to be about your passport. It's going to be more about your story. It's going to be more about your eligibility. It's not going to be about your passport. In fact, if you claim, as most asylum applicants do, if you claim that you cannot go back to your home country, then of what benefit is the passport of that country? Is of no value to you. You can only use it to travel to other nations, but definitely not to your home country. And of course, if asylum if your asylum application is approved, if you need to travel, there is a temporary passport that Department of Homeland Security will give you, which you are able to use to travel to other countries apart from your own native country. So it does not matter. To answer your question, does it matter? No, it does not. It does not matter. Please keep the questions coming. Keep the questions coming. And please remember to invite your family and friends. We do this every Wednesday, 12 p.m. Central Standard Time. We do this every Wednesday. Subscribe to our channel so that when we go live, you'll be notified. And also, you can send us text or on regular number. You can also send us text on our WhatsApp number. You can suggest a topic you want us to discuss. If so far we are not discussing topics that are of interest to you, if you have any topic that is of interest to you, you can send us email and let us know what topic you want us to discuss. So you can do this ahead of time. You can send in your questions ahead of time. You can also send in your question live as we are doing this. You can also call in. Our number to call is 817-893-4495. Oh, okay. 817-883-4495. 817-883-4495. So you can call in, you can send a message through WhatsApp. You can also send a regular text through WhatsApp. So the number once again, 817-883-4495. 817-883-4495. So keep the questions coming. Keep the questions coming. Keep the questions coming. Remember to invite your family and friends so that they also partake in this free information session every Wednesday, 12 p.m. Central Standard Time. So keep the questions coming so that we can answer the questions directly instead of expending valuable time on questions on areas that may not be of benefit to people who are watching us today. So keep the questions coming. I think I just answered the last question that we received about the Venezuelan passport that was cancelled. The answer is yes, it does not matter. Cancellation of your passport does not affect your eligibility for asylum, and cancellation of your passport is not going to have any impact on your application. It does not matter whether your application is approved or not. I think I can hear you. So keep the questions coming. Keep the questions coming. FGM is an interesting topic, and it was only added to U.S. immigration law in 1996. Before 1996, female genital mutilation was not recognized as a ground for asylum. but that changed in 1996. Yeah, USCIS policy on asylum changed in 1995, and that 1995 change in policy was first recognized by the Board of Immigration Appeal in 1996 in matter of 80. That is when female genital mutilation officially became a ground for asylum in the US. But again, applicants will have to show that they have suffered past persecution or credible fear of future persecution in order to get asylum based on female genital mutilation. Okay, I think we have other questions. I left my country because of fear of my daughters getting harmed. FGM by my daughter's father and his family. Now I'm here in the US and I have asylum pending. My daughter's father is now in the US too. So what's the question? And he wants me to include him in my application. Will this not contradict my situation? Well, this is not a straight yes and answer question for me because there's a lot that I don't know. For example, I don't know what story you presented to immigration in your asylum application. I don't know whether your story implicated your husband as supporting the culture, or maybe your story indicated that he was helpless, because they are two different things. If his role was that of a father who was torn between obeying his culture, his parents, his family, and the culture versus the children's interest, or you as a wife, your interest, that is a different ball game. But if he actively participated in the persecution, in the desire to have your children circumcised, then that would be problematic. But again, it depends on a lot of things that I don't know. So this is not a yes or no question. It's not something I can tell you, yes, add your husband, or no, don't add him. It's not a yes or no question. I will need more information in order to do this. Or maybe if you have a lawyer who is representing you, you can discuss this with the lawyer to let the lawyer know that your husband is now around and wanted to be a part of the application. But one thing is certain: if he was an active participant in the persecution or the fear of future persecution, then he will not be eligible for asylum. But again, that is not something I can determine without additional question or additional information. The next question: can a minor apply for asylum? Sure, yes. A minor can apply for asylum. In fact, I'm not sure if you are familiar with the news here in the US. You will see unaccompanied minors crossing the border into the US. I mean, yes, a minor can apply for asylum. Asylum is no respecter of age. When somebody is fearful of his life, when somebody is running away from credible fear, age will not matter. Age will be immaterial. Yes, minor can apply for asylum. The next question: I'm from Ghana. I had a student visa in France. I went back to my country after I finished my education. and then came to the US, can I apply for asylum here? Again, this question is not a yes or no answer. I don't know how much of this podcast that this person has listened to. I don't know whether this person is just joining us. All this background you gave is really immaterial to your eligibility for asylum. The most important thing is, are you eligible for asylum? And in order to be eligible for asylum, you have to show, one, that you have been persecuted, and the persecution was from the government of your country, not from a private individual. The persecution was from the government of your country, or from someone that the government is unwilling or unable to control. That is the first requirement for asylum. Now, if you meet that requirement, then you have to show that the reason that the government is persecuting you or has persecuted you, or you have a fear of future persecution from the government, is either because of your race, religion, nationality, membership in a particular social group, or political opinion. So you have to show that the persecution has come or is coming from the government of your country, or someone that the government is unwilling or unable to control. In addition, you have to show that the reason, because in some legitimate cases, the government may have a legitimate reason to persecute you. For example, it is the duty of the government to have somebody who committed a crime, to have them arrested, have them persecuted, detained, jailed, or even in some limited situation, maybe tortured. So somebody cannot go and commit a crime and then run to the US and say, oh, the government is the one trying to persecute me. So you have to show that the reason that the government is trying to persecute you or has persecuted you, or you have a fear of, is either because of your race, or your religion, or your nationality, or because you belong to a particular social group, or your political opinion. Now, if you meet those two requirements, the third requirement is that you must apply for asylum within 1 year of entry into the United States. So, talking about you going to school in France, and then going back to your country after you finish your education, yes, the only time that narrative can impact your asylum eligibility is if the act of persecution that you are referring to, if it happened before you went to France, before you went to school. Yes, American government or immigration can ask the question, okay, if these things happened before you went to France, why did you not apply for asylum in France while you were in France? That is a legitimate question that they can ask you. But if it is a persecution that happened after you return from France, or if it is a continuing persecution, it may have started before you went to France, but maybe you didn't know that it will continue, and then you came back and it continued. Yes, you can apply for asylum if you met all other requirements. So I believe that I've been able to answer that. And if there are things you want to clarify in that, you can send in your clarification. But the point here is that when you apply, please keep the questions coming. The point here is that when you apply for asylum, you are saying that the government, in fact, whenever you apply for asylum, you are indicting the government of your home country. You are indicting them. Either you are accusing them of the one trying to persecute you, or you are saying that they do not have the capacity or they are not interested in arresting or dealing with those who are persecuting you. So it's an indictment on the government of your country. And that is one of the reasons why the bar is high. You have to be able to show that the government is the one doing it, or that the government is unable or unwilling to persecute those who are actually doing it. So keep the questions coming. Keep the questions coming. Okay, we have a new question here. My first application I filed was asylum, still pending. But I recently married this year. Will this affect me in any way? On asylum or being married now? Well, again, this is not a yes or no answer. It's not a yes or no question. I cannot tell you ahead of time whether it will affect you either in the marriage petition or in the asylum petition. But one thing that I'm able to tell you, which I've stated multiple times, either in today's podcast or in previous episode, is that once immigration makes a determination that your asylum application is frivolous, it is a permanent bar. It is a permanent bar. So it is very, very important that you prevent that frivolous finding. So if they make a frivolous determination about the asylum application, your marriage will not solve the problem. Even if you marry the American president or the daughter of the president, it will not solve the problem. The challenge here is more about frivolous finding. So you want to ensure that there is no frivolity in your application. Now, if you are married to an American citizen and your application is pending and you have not been interviewed, yes, you have the privilege, you have the opportunity to switch your application from asylum to family-based. For as long as you are not in removal proceedings, immigration will do that switch, and then you send a letter to the asylum office requesting to withdraw your application. Because except the frivolity is so glaring, it is unlikely that immigration will make a frivolous determination before interview. It is very unlikely. So that is a determination that they will probably make after you have been interviewed. So if, according to this question, if you have not been interviewed and you submit an application, you switch your application to family-based petition based on your marriage, you then send a withdrawal letter to immigration requesting to withdraw your asylum application. In fact, in this type of situation, I will advise you that you file your petition first. Let your U.S. citizen spouse submit a petition on your behalf, get the receipt notice, and then send the receipt notice, attach a copy of it to your withdrawal letter to USCIS, so that the reason for your withdrawal will be because of your marriage to the USC. So with that, it is unlikely that they will go ahead and conclude or make a frivolous finding after you send such a withdrawal letter to them. It is unlikely. But if, on the other hand, if you are already in removal proceedings, then immigration will not have the jurisdiction over your petition. So you will still have to submit your family-based petition and the application to immigration judge. Then it is the immigration judge that will now make that determination, and then you can withdraw your asylum application in court, and then the immigration court can allow you to switch your application to the family-based petition. So that is the way that works. So you can still go ahead and withdraw it for as long as you have not been interviewed, no frivolous finding has been made either by USCIS or by the immigration court. You can still withdraw it and switch your application to family-based petition. Please keep the questions coming. Next question. I don't know if this is under asylum talk or another case type. My son has been here since a young child, but I never filed for him. He is now 18. Will he have a difficult time adjusting? Again, this question is not very clear. So if you are talking about adjusting based on what? Because there are so many factors that determines whether your child whether your son will have a difficult time or not. Number one, what is your own status? Number two, what is your son's current status? You Are you already a permanent resident? Are you already a U.S. citizen? Did you file an application that you didn't include your son? If you are married to a U.S. citizen, did your marriage occur before your son turned 18? There are so many questions. There are so many unanswered questions, and it is going to be difficult to answer this question without having a lot of additional question. Okay, I think this person is trying to clarify the question. I am a citizen now. I did not include him. Well, again, there are still, even though you try to clarify this, it's good to know that you are a citizen, but there are other things that I still need to know. For example, are you a male or female? Are you the mother or are you the father? In your application, I know that before you become a U.S. citizen, it does not matter whether you got your citizenship through marriage, through family base, or through employment base. It does not matter. There are several applications where they will ask you to list all of your children. And I'm sure that even right from your application for visa, if you enter the US with a visa, you probably will have been asked how many children you have and all that. So there are still a lot of questions to be answered. Okay, I see more clarification. You are the father. Okay, now again, as this child, as his name come up in any of your prior applications? Have you ever in all the applications where they ask you to list your children, starting from when you apply for visa? Did you list him that you have this child? Starting from when you submitted your application for permanent resident from I-485, you have to state all the names of your children. Did you list him as one of your children? Starting from the I-130 petition, especially the I-130A, we ask you for the names of your children. Did you ever mention this person's name? Starting up till when you submitted your N-400, that is the application for citizenship. That is also an application that we ask you to list all of your children. So the question is, it is possible for you to have listed him at one point, but did not include him as applying. That is straightforward. If that is the case, if you have listed him, oh, okay. Oh, I never listed him. Oh, okay. Well, I was going to say, if you have listed him as having him as a child, but you didn't process the application together, that would be easy to fix. All you need to do is just to submit I-130 petition for him. Because he is just 18, he will still fall under immediate family, and you'll be able to petition for him. However, since you stated that you have never listed him, that will be problematic. That will be very, very, very problematic. Problematic in that you cannot just turn around and claim to have an 18-year-old child. Because even under American immigration law, anybody aspiring to become a U.S. citizen, they must show evidence of responsibility over their children. In other words, if you have a child or if you have children, it does not matter where they are in the entire world, whether they are in the US or not. If you apply for citizenship, you must show by documentary evidence how you have been taking care of these children, because it is one of the major requirements for anybody to become a US citizen. If you have a child and you never took care of that child, then you are not eligible for citizenship. If you have an obligation to pay child support and you never pay the child support, or you owe back child support, you are not eligible for citizenship. So there are lots and lots of things that you will have had to show, you will have had to prove in order to become a US citizen. And because you didn't disclose this child, it means you cut off a line of inquiry by immigration. And secondly, it can also put your own citizenship in jeopardy. Now, having said that, I want you to understand, immigration is not a one-cap-fits-all. This is a general statement that I'm making based on the questions that are coming in on general level. I will still advise you to consult individually, one-on-one, with any experienced immigration attorney. But if you choose to consult with us, I will advise you after this program or at any time of your convenience, contact the office so that I'll be able to ask additional in-depth questions which we may not be able to discuss in a situation like this, and then be able to tell you if there's anything at all that you can do to solve this problem. But apparently it is a major problem, because if you don't handle it with care, it can actually put your own citizenship in jeopardy. So that would be my advice. Please keep the questions coming. Please keep the questions coming. Keep the questions coming. Today we are continuing our discussion on asylum, and today we are discussing female genital mutilation. Actually, we are discussing membership in a particular social group. So female genital mutilation is one of those membership, is one of those classification under membership in a particular social group. Other areas of membership in a particular social group could be members of LGBT community. Surprisingly, nobody has asked any question about membership of LGBT community. That is another thing that one can use as the basis for membership in a particular social group. So if you belong to LGBT community, that is another ground for applying for asylum if you have been persecuted or if you have a credible fear of future persecution. Earlier we were discussing questions about Nigeria, where I stated that Nigeria has actually enacted a law making it illegal for anyone to circumcise a child in Nigeria. I can tell you that talking about membership in a membership of a LGBT community, that is another area where the Nigerian government has actually made a law making it illegal for anybody to belong to LGBT community. So that may be a positive thing for those who are eligible in that category, because that means it will be much easier to prove that the government is not going to be able to protect such an applicant where the government itself has criminalized membership of that community. So that's going to be much easier to prove. But of course, there are other eligibility criteria that will have to be met before somebody can be approved for that. Now, I have other questions. Before I digress, let me answer the questions first. Can I claim asylum after 1 year? Oh my God. I'm sure these are new people who are just joining. We have discussed this over and over and over and over. One of the requirements for asylum is that you must apply for asylum within 1 year of entry into the United States. So the simple answer is no. However, having said that, the law allows for what is called changed circumstances. The law allows for changed circumstances. Now, let me tell you, ignorance of the law is no excuse. Oh, I didn't know. Nobody told me about it. Oh, that is not changed circumstances. What is considered changed circumstances has to be something major. For example, maybe while you are here and you are planning to go back home, then maybe war broke out in your home country. That would be considered a change circumstances, or something happened that was never envisaged. Maybe, for example, maybe there was a coup in your home country, and that coup affected you or your family member. So based on that changed circumstances, you are not planning to apply for asylum before, but now considering this thing that just happened, you now decided to apply for asylum. That is why you are filing your application late. So it has to be something major. It cannot be something like, oh, I didn't know. Oh, nobody told me. Oh, I didn't hear about asylum. No, all those is not a requirement. All those are not an excuse for somebody who applied after 1 year of entry. In fact, I can tell you from my experience, I cannot remember seeing any immigration officer or an immigration judge approving an asylum that was filed after 1 year. I cannot. But what I do know is that if you are eligible for asylum and you didn't apply within 1 year of entry, the U.S. government, the USCIS officers, they do not have the authority. They do not have the authority to approve it if your application is filed after 1 year of entry. However, if you are in removal proceedings, the immigration judge may deny your asylum application and then go ahead to approve your withholding application. They may deny your asylum application, but go ahead to approve the application for withholding of removal. That is what I've seen that is very common for those who are eligible for asylum but did not apply within 1 year of entry. Of course, approving withholding of removal is not the same thing as approving asylum, because withholding of removal can only give you employment authorization. From the name withholding, it means that the immigration judge will have ordered you removed first. It is only after that they will now withhold that removal. They will now give an order instructing ICE, that is Immigration and Customs Enforcement, to hold on removing you. You have been ordered removed, but please don't remove this person yet. So you are not going to get any benefit out of it other than employment authorization. Unlike asylum, in the case of asylum, you once you are granted asylum, 1 year after, you can apply for green card. And of course, 5 years after becoming a permanent resident, you can apply for citizenship. You don't have all these benefits when it comes to withholding of removal. But of course, with the withholding of removal, you will not be deported, but you can only get employment authorization. Next question. I had never heard of FGM before. Is this a common practice? Well, it depends on your culture. It depends on your culture. FGM is rampant in some cultures. So if you have never heard about it, apparently you are not from a culture where those things happen. But of course, in some cultures, yes, women are circumcised. Several sensitive parts of their private parts are surgically removed. And most of the time, these things are done in a very crude way, in such a way that it leaves permanent pain on girls, and in some cases leave permanent burden on girls. And in some cases, this could be a lifetime problem. Some women after FGM, they find it difficult to have romantic relationship with the opposing party. They find it difficult in some cases to even maybe enjoy sex or do any. Some even find it difficult carrying pregnancy. I mean, there are so many effects. There are so many terrible effects of female genital mutilation. And like I said, majority of the times, these things are carried out not in a clinical setting, but more in a barbarous setting where you have stark illiterates performing this traditional surgical operation. So it's something that is common in some cultures, and it should not surprise you that it does happen here in the United States. There are some areas here in the United States where FGM is carried out, even though illegally. But of course, if they are caught, it's going to be straight to jail. But I just letting you know that it does happen, even here in the US. Talk less of Africa or some other cultures. Yes, it does happen. But apparently, if you have not never heard about it, that is a clear answer that you are not even eligible for it. So don't even think about it. So let's keep the questions coming. We have about 20 more minutes to go. Let's keep the questions coming. I have heard about this new program for Haitians, Cubans, Nicaraguans, and Venezuelans that people are talking about. I don't I don't understand what the question is here. Okay, is it continuing? Sponsoring family members in our countries of origins to bring them here for as long as we are permanent resident or US citizen. Is it true? If it is true, who can we sponsor? I'm not sure I understand what this person is saying. I mean, sponsoring family members has always been part of the immigration law. That is not something that is new, and that is not limited to these countries that you listed. Anybody who is a US citizen or a permanent resident can always petition for family members. The only difference between a US citizen and a permanent resident is that US citizen can cover more areas, can cover more who for children who are under 21, A permanent resident can petition for children who are over 21 but unmarried. But a U.S. citizen, on the other hand, can go beyond that. A U.S. citizen can go beyond that. A U.S. citizen can petition for spouses. A U.S. citizen can petition for uh, unmarried children under 21. A U.S. citizen can petition for unmarried children over 21. A U.S. citizen can also petition for married children irrespective of age. A U.S. citizen can also petition for maybe siblings. Of course, permanent resident cannot petition for siblings, but a U.S. citizen can petition for siblings. So I'm not sure if this is what the question is all about. So, but if you are talking about if you are talking about the response to 80s, I think it was a earthquake or something. I'm trying to remember something. There was a natural disaster that happened in Haiti that this temporary program was created where somebody from that part of the world who have sponsors here in the US can stay with them temporarily. I really don't have a lot of I really don't have a lot of information in my head on that right now, but probably I can check it out and we can discuss it next week if you bring it up. I really don't have a lot of information about it, and I don't want to, whatever I say here, you can take it to the bank. So whatever I'm not sure of, I'm not going to say it. So for that reason, I'm not going to be able to comment on that now, but I can check it out. You can bring up the question next week and I will tell you what my findings are. So please keep the questions coming. Keep the questions coming. Keep the questions coming. Let me see the next question. Okay, that seems to be the last question for now. Please keep the questions coming. Okay, the last question is the one I have heard about this new program for Haitians, Cuban, Nicaraguans, Venezuela, that we are talking about sponsoring family members in our countries of origin to bring them here for as long as we are permanent residents or U.S. citizens. Like I said, I don't know a whole lot about this, but if it is what the one I know about, it is something that is on a case by case basis. It's not a blanket thing, and I think it's only limited for up to 2 years. If it is something, if it is the one I think I heard about, but again, it's not something that I can be quoted on that. I'm not, my facts are not accurate on that. Keep the questions coming. Can you share more information on asylum based on your experience with clients? We have been discussing asylum since last week. we have been discussing asylum since last week, and that is why we decided to continue this week, because we realized that is a very delicate and interesting topic. From my experience, what I have seen from my experience with clients is consistent is consistent with immigration finding. I said earlier that 95% of asylum applications in the United States are denied. They are not denied because people didn't submit a good application for asylum. They are denied because majority does not even understand what asylum is all about. And I've seen this over and over and over. And if you are talking about experience, what my experience with clients has done, especially clients of African origin, what my experience has done is that most people, they apply for asylum, and then 180 days after the application has been pending, because they are eligible to apply for employment authorization, and then they apply for employment authorization and they get it, and then they get social security, they go around spreading the false news, the false information that their asylum application has been approved. That is an experience that I have seen. And quite honestly, that is one of the major reasons why we do this program, to educate people, to let them know that the fact that you have been given employment authorization has nothing to do with the merit of your asylum application. In actual fact, I explained last week that asylum applications are processed in a specialized office. They are not processed at every USCIS office. As big as Texas is, only 2 offices process asylum application. One is in Houston, the other is in El Paso. They don't process asylum, for example, in Dallas. They don't process asylum in Austin. They don't process asylum in San Antonio. So it is only people whose application has been pending. Okay, now this 180-day thing, I think I need to clarify that too, so that it doesn't create additional confusion, because I keep saying that asylum is so complex, or immigration law generally is so complex. I've been talking about 180 days, 180 days, 180 days before somebody is eligible for employment authorization. I want to clarify that the 180 days is applicable to you if you are in removal proceedings. If your asylum application has not been referred to immigration judge, or you did not submit a defensive asylum, you can be eligible for employment authorization if your application has been pending for 150 days. That is 5 months, as opposed to the 160 days, 6 months for people who are in removal proceedings or people who submitted defensive asylum application. So now, application for employment authorization, they are generally processed at the National Benefit Center. They are not processed at the asylum office. So the fact that you applied for employment authorization and you are approved, it does not even mean that immigration have looked at your asylum application. Because those who will look at the application, they are not the same set of people who will process your employment authorization. The only reason you are getting the employment authorization is because they don't want you to become a public liability. They don't want you to become a public charge. So they know that you need to survive. You need to pay your bills. That's why they want you to keep working while they are processing your employment authorization application. However, some people misplaced this. Some people misunderstood this. Some people misinterpret this to mean that, oh, if they don't believe my story, why would they give me work permit? My brother, my sister, you are wrong. It is the system here. The system here, they are realistic. They know that you need to work. They know that you need to pay your bills. They know that you need to survive while your application is pending. That is why they are giving you work permit. It is not because they believe your story. So that is one experience that I've seen with people. people who are not eligible for benefit, but they are not only applying for it, but they are also encouraging others. That is why you see a lot of people who have been here for years before applying for asylum, because those who came in, apply for asylum, then got work authorization, they will start telling them, oh, you have been here, look, somebody just came, he already got employment authorization, he's already getting this, he's already getting that. And now people who are not eligible, they will now go ahead and start applying. So that is part of my experience. But if you are also talking about my experience is in representing people in an asylum application, I can tell you that for those who started with us, those whose application we prepared and filed, we have extremely opposite percentage when it comes to approval record. As I said earlier, 95% of asylum applications are denied. I can tell you that applications that we started in this office, that we processed, believing that the applicant met the requirement, 95% or more are approved in this office. So that is my experience. Next question. We have about 10 more minutes to go, so let me quickly go through the next question. Asking this question for a friend. She has been on asylum status for 7 years and concluded nursing program. Can the person change status based on completing nursing? You see, this is part of what I just explained now. All this misunderstanding about asylum. I don't think this person has been on asylum for 7 years. That cannot be possible because, like I said earlier, if you have been granted asylum in 1 year, after 1 year, you are eligible to apply for permanent residence. So maybe what this person is trying to say is that her friend has a pending asylum application for 7 years. That is the only reasonable interpretation that I can give this question. That is the only reasonable interpretation that I can give it. Other than that, if this person has been on asylum status for 7 years, this person ought to have become a U.S. citizen by now. So I'm sure that this person, the question is not indicating the right status. But now, assuming that I am right, assuming that this person has a pending application for the past 7 years, whether the person can switch to apply for permanent resident status based on nursing program, that is a different ball game. There are a lot of questions about our office. There are facts that I will need to know before I can answer this type of question. For example, did this person apply for asylum before the expiration of his or her I-94? If the answer is yes, and she has already completed her nursing program and she's licensed by at least one state here in the United States, and there is a sponsor willing to sponsor her, file I-140 petition on her behalf, yes, she may be able to adjust status to that of lawful permanent residence based on the nursing program. But again, that is assuming that all these other requirements are met. One, the asylum application must have been filed before the expiration of the I-94. Two, the person must have completed the nursing program and passed at least one state board nursing exam. And three, there must be an employer willing to file I-140 petition on her behalf. If all these three requirements are met, yes, he or she can change status, apply for permanent resident status based on the nursing program. But if this is one of those cases where the I-94 has already expired before the asylum application was filed, then the answer is no, she cannot. Because she will not be eligible for uh, application for permanent resident based on nursing if she was already out of status. Because if she did not apply for asylum before the expiration of her I-94, it means that she will be in unlawful status and unlawful presence. But if she applied for the asylum before the expiration of her I-94, she will be in unlawful status but in lawful presence, which will make her eligible for adjustment of status. So I hope I've been able to clear that. The next question. I came to the U.S. Okay, I see that this person is trying to clarify the question, but well, I was right, or I already answered the question based on the assumption that this was a pending asylum. Yes, the simple answer, if the application for asylum was filed before the expiration of the I-94, yes, the only other requirement is for her to pass at least one state exam, nursing board exam, and then she need a sponsor to file I-140 petition on her behalf, and then she can apply for adjustment of status based on the nursing program. The next question. I came into the U.S. through the southern border. I'm from Venezuela. I was allowed in the country, but I was not paroled. And some people have been telling me that I can ask for this. Is it true? Well, parole is something that is discretionary. So usually, if they are going to parole you, they will have done it when they release you. But the truth of the matter is, can you ask for it? Yes, anybody can ask for anything. Even the Bible says, Matthew 7:7, ask and you shall be given. So anybody can ask for anything. But will you be given? I can't guarantee that. Usually, parole is something that they do at the time they were going to let you in. And most of the time, before they parole you, they must have conducted what is called credible fear interview. So they will have conducted credible fear interview for you. So if you pass the credible fear interview, then the officer now use his or her discretion to decide whether to parole you or to just release you on bond. So if you are paroled, then you will have the opportunity to adjust your status. You have the opportunity to change your status. You have the opportunity to do things that people who enter the United States legally can do. But if, on the other hand, you are not paroled, but you are maybe released on bond, or you are granted bail, or you are released on self-recognizance, in either of these, you cannot change your status. You cannot adjust your status. Your options will only be limited to asylum, except in family-based cases where you may apply for I-601 unlawful presence waiver, in which case you will still have to go back to your home country to go and process your adjustment application from there. So the simple answer is you can ask for parole, but there is no guarantee that you'll be approved. I believe with that, we are going to come to the close of today's program. Again, remember to invite your family and friends. We do this every Wednesday, 12 p.m. Central Standard Time. That is 12 p.m. Dallas time. This is our own way of giving back to the society, to encourage people, to prevent people from making errors, from committing avoidable mistakes. So that is the only reason we are doing this, and it is only fair that you you invite family and friends so that you don't monopolize this information. So invite your friends. Next week will be another day by God's grace. And before next week, if you have a topic that you want us to discuss, you can send it in. If you don't have any topic, we will come up with our own topic. But if you have interesting area of law, interesting area of immigration law that you want us to discuss, you can let us know. So you can send in your messages to our WhatsApp number 817-883-4495. 817-883-4495. This is our dedicated line for this podcast. Our office, we have other phone numbers, and I know part of our numbers are 817-983-4499, 817-891-6655. We also have land phones, 817-274-1144, extension 602, 817-274-1844, extension 603. But this particular number, 817-883-4499, is a dedicated number for this podcast. So there is no way you will send a message to that number for the purpose of the podcast that we will not respond to you. It's a dedicated line, specifically dedicated for this podcast. Every Wednesday, by God's grace, we will be doing this program. And in the future, we are also considering bringing in guest speakers where you will have the privilege of listening to other opinions. So this will be going on by God's grace very shortly. So we can't make a promise now because we have to, whoever we are going to bring in as guests, we will have to get their permission first before we can do that. But for now, the program continues by God's grace every Wednesday, 12 p.m. Central Standard Time. That is 12 p.m. Dallas time. God bless you, and thank you for joining us today.
Busted. When he said, well, this is what, he made it look as if it was going to be like, and then he now, congratulations. He didn't say you were approved, he said, we have been approved.
They get so excited, they're happy, they start crying, they're just super excited. I had times where I cry with them because you feel what they're feeling. And you understand what they go through, and it, like I mentioned, like we all handle their case, we all know their cases, and it's like I am one of them, and I understand what's going on, and I'm happy for them that it's finally ended and they are now where they want to be. That is our main goal.
And I jumped. I didn't know how or where the strength came from. I didn't even think I could knock him down. I held his neck because that particular issue was so naughty. But God just used him and everything was resolved and I got my approval. The entire office, they were so happy, they were jubilating as if it was one of them or their own child.
Having someone go from a super low to a high of something, such a positive result, it feels amazing, honestly.
It's really, really a big challenge. But again, we were able to put smiles in her face and we were able to get her substantial amount of money from the insurance company. Even after paying all her medical bills, she was able to smile to the bank.
Our clients love us because we care. Their experiences are our experiences. Their joy is our joy. Their sorrow is our sorrow. So we really, really care about everyone that walks through those doors. And I think that that's what makes us special.
And then I rolled on the ground. All of them, Nigerians, how we react to issues. I was rolling on the ground, thanking God. Is that not caring what I was wearing or who I was looking? But the good thing is that the entire office was happy with me, not for me, because they felt that it was their win, it was their own. And we all celebrated. It was a good thing.
Another interesting thing about our office, we try as much as possible to put smiles in our client faces.
As soon as we call that client, it's such a great feeling. I mean, at first when we're pranking them, I feel so bad.
I was coming from work. Because like I told you, I'm like a member of this family. And call Asekun, he wants to talk to you.
There is a strategy that we like to do. We like to surprise them. We would call and Mr. Olu would talk to them, letting them know, well, maybe something has gone wrong with their case.
He made it look as if there was no approval. But then I announced, okay, I'm coming to your office. He said, okay, but just drive carefully and things like that. So, okay, I'm waiting for you. Then when I came into the office, even the receptionist, her face was just blank. What is happening? He said, okay, let me tell him that you're around. I went to the office. He had already assembled the entire staff. And when I came in, wow, the balloon just busted. When he said, well, this is what, he made it look as if it was going to be like, and then he now, congratulations. He didn't say you were approved, he said, we have been approved.
They get so excited, they're happy, they start crying, they're just super excited. I had times where I cry with them because you feel what they're feeling. And you understand what they go through, and it, like I mentioned, like we all handle their case, we all know their cases, and it's like I am one of them, and I understand what's going on, and I'm happy for them that it's finally ended and they are now where they want to be. That is our main goal.
And I jumped. I didn't know how or where the strength came from. I didn't even think I could knock him down. I held his neck because that particular issue was so naughty. But God just used him and everything was resolved and I got my approval. The entire office, they were so happy, they were jubilating as if it was one of them or their own child.
Having someone go from a super low to a high of something, such a positive result, it feels amazing, honestly.
It's really, really a big challenge. But again, we were able to put smiles in our face and we were able to get her substantial amount of money from the insurance company. Even after paying all our medical bills, she was able to smile to the bank.
Our clients love us because we care. Their experiences are our experiences. Their joy is our joy. Their sorrow is our sorrow. So we really, really care about everyone that walks through those doors. And I think that that's what makes us special.
And then I rolled on the ground. All of them, Nigerians, how we react to issues. I was rolling on the ground, thanking God. Is that not caring what I was wearing or who I was looking? But the good thing is that the entire office was happy with me, not for me, because they felt that it was their win, it was their own. And we all celebrated. It was a good thing.
Another interesting thing about our office, we try as much as possible